name is Kiana Trabue. I'm the Vice Mayor here in the Village of Woodlawn. On behalf of our Mayor, Brian Poole, my fellow council members, our village administration, and our residents, I would like to welcome you to the beautiful village of Woodlawn. For those of you who are not familiar with our village, we are a small but mighty village here in Hamilton County. We are on 2.5 square miles, and at the last census, we had about 3,300 residents. Again, I would like to thank you for attending tonight on this very important topic. Thank you to the Center for Social Justice for partnering with us to put on this community forum around Stand Your Ground. At this time, I'll turn it over to Raquel Smith, who is Executive Director of the Center for Social Justice.
Thank you, Vice Mayor Trabue. At the Center for Social Justice, we work with communities and police departments to accelerate police reform in Southwestern Ohio. We are happy to partner with the Village of Woodlawn on this work. Our goal is to eliminate racial profiling as a practice, to reduce uses of force, to ensure police accountability in our region, and to establish community oversight of law enforcement in every single municipality. Today, we partner with Woodlawn to provide you with some important information that the community has been asking for years. There's been a long-term conversation about stand your ground laws, and recently Ohio expanded its stand your ground law. So today we are going to give an overview of that law, talk about its impact on communities, and give you a law enforcement and attorney perspective on how this plays out in the legal system. Our presenters today include Center for Social Justice staff, Kendra Reeves, our social justice advocate, Tiffany Michelle Brown, our social justice community organizer. We have community leader and attorney Fanon Rucker of the Cochran firm. And then also, last but not least, from the Village of Woodlawn, Chief Aaron Tillman. And with that, I will kick it over to Kendra Reeves to start us out.
Hello, everyone. Thank you again for joining us for this forum. So I'm going to start off by talking about what is Stand Your Ground. So in the simplest terms, Stand Your Ground is a legal defense that allows you to protect yourself. To the technical sense, Stand Your Ground is a legal defense that allows you to use lethal force whenever you feel threatened, anywhere that you're legally allowed to be. And depending on what state you're in will determine if you have the duty to retreat. And duty to retreat just means whether or not you have to show that you attempted to escape before using lethal force. And since they expanded the Stand Your Ground law here in Ohio, you no longer have the duty to retreat. But we'll get into that a little later. So how it started. So while there's always been laws on the books here in America to defend yourself, Florida really kicked off what we see as Stand Your Ground laws back in 2005. And when Florida implemented the Stand Your Ground law, excuse me, they removed the duty to retreat. So you no longer have to show that you made any sort of attempt to protect yourself or escape before using lethal force. And you can do this, you can protect yourself anywhere that you are legally allowed to be, whether or not that's your house, your car, your neighbor's house, anywhere in Florida, you can protect yourself. And since Florida implemented their Stand Your Ground law, there's been 38 other states that implemented this statute as well, Ohio being the 36th. So let's get into the Ohio version of the Stand Your Ground laws. So Ohio implemented its Stand Your Ground law in 2008. And here, this iteration, Ohio included that if you are in your house or in your car, you do not have to show a duty to retreat. So if you feel threatened and you're in your house, in your car, you can protect yourself. Outside of those realms, you cannot use that as a legal defense. And that was back in 2008. Recently, last year specifically, the Senate, the Ohio Senate introduced Senate Bill 174 that expanded the Stand Your Ground laws. And Governor DeWine signed this bill in January of this year, and it became in practice in April. Excuse me. So this version of the Stand Your Ground law removes the duty to retreat. So you no longer have to only be in your house or in your car, and you no longer have to show that you attempted to escape if you feel threatened. You can use lethal force if you feel threatened anywhere that you're legally allowed to be. Now, knowing what we know, so if you look at the data that's been shown in other states, Stand Your Ground hasn't been the best law for Black people specifically, whether you're the victim or you yourself are defending yourself. Because we knew this, we as the Urban League completely stood against this law. We asked Governor DeWine us and other Ohio organizations asked Governor DeWine not to sign this bill. There was even implications in December of last year that he was going to veto the bill, but that didn't happen, and he went ahead and signed the law anyways. So that's where we are in Ohio. So I'm going to pass it over to my colleague, Tiffany, who's going to talk about the implications of this statute.
Thank you, Kendra. So while we know that Senate Bill 175 has been passed and has been enacted as legislation here as of April of 2021, how does Stand Your Ground affect communities? And that's what I'm going to talk about today. It is the position of the Center for Social Justice that Stand Your Ground laws give people a license to kill, allowing those who shoot others to obtain immunity, even if they started the confrontation. And we've seen some of those confrontations happen around the country where individuals approach others, escalate a situation, and then feel threatened, whether they call the police or whether they begin to use lethal force. They escalate the situation, posing a potential danger to communities. Convictions in Stand Your Ground cases have been skewed unfairly against people of color, with particular bias observed through research against Black people. In Stand Your Ground states, we have noticed through research that these laws are associated with an increase in homicide rates. Florida, for an example, has a 75% increase in justifiable homicide cases and 22% in unlawful homicide cases. More than 150 gun deaths are reported each month in the United States overall. Stand Your Ground is associated with 8% net increase in the number of reported murders and non-negligent manslaughters. And more than likely, you are, as a Black victim, excuse me, I'm going to start over here. More likely to avoid charges if the victim was Black or Latino, but not if the victim was white. So this disproportionately affects how this law is applied to cases as a defense. You are 2 times more likely to be convicted in a case that involves a white victim compared to those involving Black and Latino victims. Homicides in which white shooters kill Black victims are deemed justifiable 5 times more frequently than when the situation is reversed. We pulled a few of the case studies that most of us all can identify with, beginning from Trayvon Martin back in Florida, where Stand Your Ground really kicked off. He was murdered by someone in his neighborhood who saw his Blackness as a threat. We seen last year with Ahmaud Arbery, where individuals saw him running, thinking that he had done something illegal, chased him down and murdered him on the street because they felt that they had to protect someone else's property. Then we have the incident with Breonna Taylor and her murder, in which it involves police. And I think this is the most important thing to note with this case, is that there was a no-knock warrant that was issued for her residence or for where she lived. Though she was not the subject of this no-knock warrant, the police entered their apartment, her and her boyfriend at the time, Kenneth Walker, and Kenneth Walker began to think that someone was intruding into their space. He would call himself protecting their home. She was then killed by police as a result of this, and he was charged with attempted murder of a police officer. The last incident that we saw here in Ohio in particular was the Ma'Khia Bryant issue, in which she called the police because she felt threatened. And in a split second, as officers arrived, there was a judgment made that ended in her losing her life when she called and she was trying to protect herself. She was standing her ground. So we want to turn this next part over to Police Chief Tillman after we conclude watching this video.
And out to a new law causing a stir tonight. Ohio is now a stand your ground state. Governor Mike DeWine signed the bill into law just tonight, despite suggesting a potential veto. Critics say it essentially legalizes murder. Supporters say it simply lets people protect themselves. Local 12's Tessa DeTiro is live tonight at Cincinnati Police Headquarters with more on this story. Tessa, good evening.
Good evening, Kyle. So just a few weeks ago, we talked with Cincinnati Police Chief Elliot Isaac about his thoughts on the bill. He was one of the Ohio police chiefs who signed a letter to Governor DeWine opposing the bill. He said in part that citizens do have a right to defend themselves, but you don't want to create an atmosphere where it's encouraged. Those types of situations are best left to trained officers. In Cincinnati, 2020 was the deadliest year on record. 90 people were murdered. State Senator Cecil Thomas thinks the so-called Stand Your Ground law is going to make matters worse.
Being a law enforcement officer for 27 years, there are going to be people out there who are going to feel emboldened now.
The law says a person has no duty to retreat before using a gun in self-defense. The Buckeye Firearms Association says it's intended to protect people only if they feel like they're in serious danger.
This law does not affect anyone until they are already the victim of a violent crime. And I don't understand why any politician or anyone else would be opposed to removing horrendous restrictions on crime victims. We should support crime victims and we should punish the criminals.
Senator Thomas stands by his belief that the law will put lives at risk.
People are going to think that if you look at me wrong, I have a right to stand my ground, and if I shoot you, I'm going to be able to tell everybody why I shot you.
The Buckeye Firearms Association thinks it will do the opposite.
If I'm the victim of a violent crime or somebody I love dearly is the victim of violent crime, I should have the ability to use any means at my disposal to save them and stop the violence.
After the mass shooting in Dayton, Thomas and dozens of other legislators called for big changes. Thomas says he's still waiting.
And that's why I read it. I wear my little do something badge. This was passed out after the Dayton shooting, and then the people were saying, "Governor, do something." They didn't mean put more guns in the hands of people. They meant pass some common sense gun legislation.
Governor DeWine referenced those reforms today when he signed the bill, and he's calling on lawmakers to reconsider them. A bill that he formerly put there it had background checks and bigger penalties for gun crimes and safety precautions. It never went anywhere. For now, live at Cincinnati Police Headquarters, Tessa DeTiro, Local 12 News.
All right, Tessa, thank you so much. And that bill also grants immunity to a place like a church, nonprofit, or others. It also allows places to have armed guards as part of their security plans. The law takes effect in 90 days.
To Chief Tillman and to Attorney Fanon Rucker to discuss the impact of Stand Your Ground on policing and the legal system.
Thank you. Just wanted to come out and support on behalf of the Ohio Chief Association to let you know that there was information that was put out by the Chief Association opposing the new law, and they drafted a letter and was sent to the governor for his consideration not to have this law go into effect. And we identified some things that would impact our positions as law enforcement And some of those things would be giving the individuals legal defense to use deadly force in situations where it's really not warranted or justified. So we wanted to let you know that our position is from the Ohio Police Association, as well as the Ohio Federal Order of Police. They're also opposed of it. They also think that this may stereotype as well as give criminals, drug dealers, the right to use deadly force where it's not warranted. So I've not found a situation where this has now been tested as case law. I could be wrong, but as of right now, I've not found anything, but maybe you'll hear more from Fanon Rucker about that with regards to if there's been any case laws and pending on that currently. I don't know that it is, but as soon as it comes up, I'm sure we're going to be challenged with that as law enforcement. It will make it very difficult for us to understand who the aggressor is versus who is actually the victim. So you need to understand as well as that the aggressor can't be the individual that's going to take this defense. So just want to make sure everyone is educated on those facts. So with that, I'll turn it over to Fanon Rucker.
Thank you so much, Chief. Thank you so much to the Urban League and to the Village of Woodlawn for putting on what is truly an important conversation. Again, my name is Fanon Rucker. I'm a retired judge. I'm also an attorney with the Cochran firm. What people need to understand about standing ground laws is that from a foundational standpoint, this changes self-defense law. And what we all understand and know, and it has been discussed here today, is that the right of self-defense, of self-preservation, is endemic. It's foundational to our very rights as citizens. But before this law changed, self-defense in Ohio requires the key is that the person who is asserting the right of self-defense could not have created the situation that created the need to use self-defense. Now, where do we see that practically? We saw that practically with Trayvon Martin. George Zimmerman started the fight. He began to lose the fight and then pulled out his gun and murdered Trayvon Martin. Stand Your Ground allowed him to start that fight, be losing that fight, and then use deadly force in order to protect himself. Prior to Stand Your Ground, Ohio, you couldn't start the fight, be losing, and then decide that you have to use deadly force. Now with our Stand Your Ground law and the change in self-defense, you can. Another huge difference in self-defense law now as a result of Stand Your Ground is the burden. Who the burden is on to prove self-defense. Now, before the law changed, it was the burden of the defendant, the person who used the deadly force or used self-defense, had the burden, had the responsibility, the duty to present evidence to support their position that they had to use self-defense in order to protect themselves. Well, now, according to the law in Ohio, with this change, it is now the burden of the state. There is a legal presumption that when a person acts in self-defense, that they're acting in self-defense when he or she uses force against anyone who unlawfully enters their residence or their vehicle. So now the burden is on the state to prove that it wasn't self-defense. That's a huge shift in how the law operates, and only because this law has changed. And of course, as we've heard tonight, as we've heard and seen in the law, this issue about the duty to retreat is really the cornerstone of Stand Your Ground. Prior to the change in the law, if a person was in a place where they could be, they first had to assess whether or not they had to run, had to get away. Stand Your Ground, as the name implies, says the person has no duty to retreat. They can stand where they are and use lethal force if appropriate. So to understand what the law is now, you really have to understand what the law was before. And as I'm suggesting, the law has changed to a significant degree. What is the impact on gun ownership and the Second Amendment? Many people have different positions about whether the Second Amendment allows an individual to have the right to arm themselves and how far does that right extend. In Ohio, we actually have the ability to walk around with guns on open carry. If you like to hide the weapon that you have to have a CCW permit, a carry and concealed weapon permit, which means you have to go through certain licensing and certain certifications in order to get it. Stand Your Ground doesn't really impact our right or our ability or our duties to hide or to walk around with our weapons. from a legal standpoint. The law is what the law is, and it's supposed to apply to everyone. And I'm going to get into that issue in just 1 second. So the impact of gun ownership and the impact of the Second Amendment, how it's changed by stand your ground laws, it's really not. The same ability that there was before this law is the same ability now. The issue is self-defense and how it actually is used. Now let's talk about why there's so much objection from such different varying views and positions. There's conservative institutes that say we're opposed to this. There are police agencies and unions who are opposed to this. There are community groups who say this is wrong. That's because of the practical application of the law. Look, there's no secret that historically our court systems have not been deemed to be fair to all people. It's not a secret. It's not something I'm just making up. Statistics and our jail populations prove this to be the case. So when people have opposition, particularly community groups, say there's a problem with stand your ground, it's not based on necessarily the letter of the law. It's based on the application of it. I'll give you an example of why this is the problem. There was a woman in Florida, that great state to keep talking about. There was a woman by the name of Marissa Alexander. In 2013, Marissa Alexander, who had been the victim of domestic violence repeatedly by her husband, was in the process of being attacked by him. Now, mind you, stand your ground was existing in that state at the time. We know that because a year before, George Zimmerman was given the ability to argue stand your ground when he murdered Trayvon Martin. A year later, African-American woman shot in the air in the garage as her husband was attacking her. And she was not allowed to use the defense of stand your ground. As a result, she got decades in prison for shooting in the air while she was being attacked. Whether and to what extent people have the ability to assert these defenses, whether the cases originally go to the grand jury, whether or not they prosecute them to the fullest extent of the law, has to do with those who are in the decision-making positions, the DAs, the prosecutors, how the judges actually assert their assert their judgment and make decisions. But ultimately, the decision-making is on individuals who are elected and who, what we know and what we've seen, don't necessarily assess all circumstances by the same standards. And so the angst and the justifiable concern about why this should not be implemented really has to do with what we have seen, what we know, and the examples that we can give about how different people in different communities, different socioeconomic classes are afforded the opportunity to use the same self-defense laws that others are. And we can say historically, they have not. And that is a concern then for the idea of vigilante justice. That's why so many oppose it. Why, as someone pointed out earlier, Trayvon Martin's blackness was something that George Zimmerman seemed to be afraid of. We can point to a number of examples like that from history around the country. A young man knocks on the door at night and the homeowner believes that he's doing something nefarious and shoots him. Fortunately, that young man actually just graduated from high school a semester early because he survived, and that man was prosecuted. Glad to hear that. But there was a young woman, same thing. She was in a car accident, and she went and knocked on someone's door at night, and they shot her and were not prosecuted because they believed that this Black woman at night was somehow there to perform some type of misdeed and was presenting a risk of threat of harm to this person. Those are examples. I mean, and look, again, we can look through the books, do a Google search. There are many examples where an individual's race or how they look provides the basis for the fear that the other person argues is the justification for using deadly force to take their lives. And that is a scary proposition. Vigilante justice. Is it really vigilantism if it's not really a true threat, but only one that the person perceives? And if they're able to use that perception as their defense, how does that give value to the life that was taken?
Fanon, I have a question for you. You talked about what the law is and then how things are practically applied. And this is actually a question for both you and Chief Tillman. Does a law enforcement officer have any obligation to make those decisions as to who was standing their ground and who wasn't when they arrive on the scene? And if they don't have the obligation, do they have the discretion to do so when they arrive on the scene?
Well, from our perspective, we do have the right to determine who their aggressor was, what was the nature for the incident, and how it got started. So all that will come out in our investigation. One of the primaries we do when we first arrive on the scene, we want to know what happened, who witnessed what, and how did we get here? Are you the victim or are you the aggressor? So we need to separate and determine who's who in that situation. And then from there, we have to make the decision who's going to be charged, if anyone. And we may have to run the information by the prosecutor's office to determine if we have the right information to move forward on, because we don't want to do something that we have to back up and we went half-cocked and we didn't have what we needed. However, this is new to us.
Mm-hmm.
We've not faced this yet. Us as law enforcement that I know of, especially in our department. So like I said earlier, I think that there's going to be a test case that's going to determine, just like anything for the first time, when someone brings it to court and they try to defend and try to use that as a defense,
Mm-hmm.
it's going to get played out. And then it's going to be the blueprint as to what the rest of the country is going to do. So we have to wait for that. We don't want that to happen, but until it happens, we don't know.
Mm-hmm.
But to answer your question, yes, we have to determine who the aggressor is, as well as who is the true victim, so that we are applying what we need to do appropriately.
Mm-hmm. And then that information is given to a prosecutor or assistant prosecutor who makes a decision whether to charge. Fanon, can you speak on like that process and especially in light of the racial biases that you've already pointed out in this application?
Sure. Well, the first thing let me say is, Chief, my question to you is determining the primary aggressor a procedure that has continued, or was that something that has to be reassessed in light of the change? Because now it doesn't seem like who was the primary aggressor is even as relevant as it used to be.
Well, we want to know how the incident occurred. We need to get to the root cause of it. And the only way we can do that is to talk to people, find out if anyone who witnessed it, put the statements together. We have to determine if, in fact, what's being relayed to us is factual, so we can make a determination who should be charged, if anyone.
Well, before I retired from the bench, the law had begun to change. And in fact, there was probably 3 months between the time that the burden shifting that I talked about with self-defense started and when I stepped down. There was never an opportunity for me as a judge to make a decision on one of those cases because it was such an incredible change in the law that prosecutors weren't prepared to present and to defend their burden of proving that, in fact, it was not self-defense when there was a crime of violence. I have not talked to any of my former colleagues about, the frequency of those types of cases. With COVID, there's been so many fewer cases that have been tried, but nobody's really talking about how that law has impacted how they try cases, particularly in Hamilton County. But it does represent an incredible change, an incredible shift in probably 150 years of jurisprudence and presenting cases of assault, felonious assault, aggravated assault, manslaughter, any of those types of things, because it is now the burden of the state to put on the argument that, in fact, the person was not using self-defense. I can tell you that with the discretion that the state has, my goodness, I've been a prosecutor, been a judge, do a little bit of defense work, civil rights lawyer. There is no more powerful position. And by power, I mean, power in the system has to do with the amount of discretion that a person has. Discretion is in the hands of the judge. The judge has the ability to decide whether someone is guilty or not guilty and whether they're going home or spending time with their families. They can make rulings on objections, and there's a large amount of discretion when they do that. The prosecutor has a great amount of discretion in deciding whether and what charges go forward, how those cases are argued and presented. If they decide they don't want to present a case, that's the power of the prosecutor. Mm-hmm. And there's no ethical requirement, there's no legal constitutional right any of us has to a particular charge for someone. So if someone is being assaulted and the police come and they say, we think there should be a charge, and the prosecutor says, well, I don't think there can be a conviction, or we don't believe based on these facts that it would be justifiable to present this to the grand jury or to actually prosecute this case, then they have the ability not to. And there's no right that the victim has to make them do it. We do have Marcy's Law, we do have victims' rights, but it doesn't give them the ability to force the state to actually move forward. So that discretion that we talk about is huge. And when it's exercised very visibly on one end and not exercised in the other, it erodes a whole bunch of trust in the system. I'm sorry, it continues to erode trust in the system that a lot of people already don't have.
Right.
But it's power and it's discretion. And so that position, prosecutor, assistant prosecutors, room prosecutors, is an incredibly powerful position because of the discretion that they have and how they move forward or don't move forward on these cases.
I have a question. I know we're talking about maybe resident on resident or community member on community member, but I want to know how does this affect use of force policy with policing? When you arrive on a scene, how do you make that split second determination? Because a lot of times, and I know in the line of work that we do, researching and assessing use of force policy, it's usually force met with force. So how do you train officers to take a step back in a heat of the moment? There's a gun involved, to not continue to escalate a situation or to use deadly force when there is a stand your ground type of event.
Well, hopefully we won't have to deal with that, but if we do, we need to, we want to treat the situation as if you're the aggressor, because we don't know. Unless the situation has already occurred and there's already a victim and there's already an aggressor. If it's actually occurring when we arrive, it's not too often that crimes are occurring as we're getting there. But if it was to occur, we have to assess what we see with our own eyes and make a determination based off what we see, and then we have to articulate those facts to the court as to what we saw when we arrived and justify our actions accordingly. So hopefully the situation has not escalated to that level, but the officers do receive de-escalating training. They're not there to pour gas on and make it a much larger fire. Their job is to get there and make sure that everyone goes home as safely as possible. That's the goal. But as we know, sometimes things are in the heat of the moment. You may see something, perceive something, you have to act on it, and then we have to put together why we did what we did when we did it.
I have a couple of questions. My first question is for you, Fanon. Going back to something that has been emphasized a couple of times around prosecutors and the power and discretion that they have. So is it fair to say that the public needs to be aware of prosecutor elections and do their research and know who's running, know information about their history, how they've prosecuted cases in the past, in order to make decisions to make sure that the people in those seats represent the best interest of the community? It's a loaded question.
I'm about to say that's offline there. Yes. No, absolutely. And what I will suggest is not just for our prosecutor, but also for our judges, for our mayor, city council members. I mean, these are people who speak for and represent us, whether we want them to or not. And so we, as informed citizens, as voices, as people of influence for those who are around us, we have to be informed and also advocate for those ascending to positions who we know by their history, not by their words during campaign season, but during their actual history and background, that they are actually advocating and working on behalf of the communities that they're claiming to come in and provide some type of justice for. That is absolutely essential. And well, yes, that's correct. Yes, that's what we need to do.
Thank you. My second question is also related to something that I've heard emphasized a couple times. Kendra, when you talked, you emphasized this. Fanon, when you talked, you emphasized it. And it's around somewhere you have a right to be. So can you talk a little bit about, how do you prove, outside of being in your own home, your own property, how do you prove you had a right to be somewhere? How's that determined?
So historically, and actually in 2008, as we discussed, the law originally changed. That was actually under Governor Strickland. Governor Strickland basically said, if you're in your own house, you have every right to take somebody out. He was a proponent of gun rights and a Second Amendment person. And so he was very aggressive about making sure that that was the change in the law. The law now has expanded. So if you're in your car or if you're on the street, that's where you have a legal right to be. Arguably, if you're in an establishment and as an invitee, you have a legal right to be there. This is as distinguished from I broke into somebody's house or I trespassed or I was told to leave and I didn't. At the point that you no longer have a right to be in that place, then you no longer have you're not in a place where you have a right to be. But it generally is if you're out in public or if you're somewhere as an invitee, but you're not trespassing or you're not committing an offense where you are, then you have a right to be there.
Thank you.
I have a question, actually for anyone can jump in. So over the past few weeks and definitely over the past year, gun violence has been a hot topic because people are dying. Not just, adults, but young people are dying of gun violence. And one thing that, I've been trying to wrap my head around is how do you have the conversation around reducing gun violence when you live in a state that's an open carry state and also you have the right to stand your ground in public spaces? So I just, that's a really loaded question too, but want to hear your thoughts on that. Like, how do you have those two conversations about reducing gun violence and protecting humans while also telling residents that they can stand their ground anywhere they're legally able to be? So,
like an idea ball.
Right. Who wants to jump in on that one?
That's loaded. That's a loaded question.
Well, let me ask, to whom? Are we talking to 15, 16, 17-year-olds? Are we talking to law enforcement? Are we talking to members of the church? Who is the audience? Because the conversation may be different depending on who is hearing the message. Not that the message necessarily is different, but certainly the way that it's communicated may be different. Because what we talk about, particularly what happened on the 4th of July, they said there were 400 to 500 reports. I saw 400 to 500 teenagers. The report was that a 16 and a 19-year-old was shooting at each other. I don't know how they knew that two people were shooting at each other and they didn't find the gun. Anyway, I'm not going to be critical about the news reports about what happened. But 16 and 19-year-old was shooting at each other and somehow, like in the movie, shot each other. And there were other folks around, perhaps maybe another shooter somewhere. So how do we discourage the idea that the average citizen should not walk around either open carry or with CCW when they're hearing these reports about these wayward teens who are out here just willy-nilly shooting folks? What I would ask is, what is the impact of Stand Your Ground going to be when we hear about these shootings in the community? Because somebody's going to argue, yeah, I was defending myself. Yeah, I'm a felon and I don't have a right to carry a gun. But do you see what's going on out here? I had to carry it. And when I shot that person, I was standing my ground. I actually was defending myself, even though we did have beef and I started it 2 years ago. Standing ground says I can start the fight and be losing and pull out a gun and actually defend myself. How are these cases going to be impacted now that the law has changed? I'd be interested to see how our prosecutor deals with them, or whether they decide they're going to present those to the grand jury when they do catch people and they don't shoot and kill each other in the process and there's still no guns found. But that's a question. Who is it that we're talking to? That's how the message is going to go. How do we have the conversation that people need to be conscious about the fact they can walk around with their guns out? I actually did I do spoken word, and one of the pieces that I did was called, I think, Consequences, something like that. But the bottom line was that as a judge, I was carrying my gun, and I have and I do. But in this poem, I was talking about how I'm driving around, I get out the car, and as a judge, I didn't have to have a license to carry. I was authorized by national federal law not to have a license to carry. That's the truth. And so I was, standing up and I was waving my hand to the police officer who thought I was, showing the weapon that I had underneath. And so he got out and shot me because as an African American in the middle of the night, he saw a man with a gun. I was waving and I was pointing to it, and he thought I was going for my gun. He shot me. Only to realize later that I had the right to carry the gun.
Mm-hmm.
So even though there may be a right, what we talk about is that discretion and that second thought, like, oh, well, that person presented a risk of harm, even though later I found out that they actually have the right to open carry because Ohio's an open carry state. That's a tough conversation to have.
Mm-hmm. Any other thoughts on that?
I would say that the individuals who feel they need to carry need to understand that there's consequences that go along with that. Even though they may not be prosecuted criminally, they still have civil burden that they may have to face, which we know that the burden of proof for proving civil matters is not as high as they are in criminal. So it's not something that, you should take lightly. There's a lot that's got to go along with that, and you got to live with the decision that you made. Some people that would haunt them, some people maybe not. But if I didn't have to carry a gun for 25 years, I probably would not be interested. I'm not a person that has 5 or 6 guns at home. That's just not me. So
says the chief of police.
Not part of my job. I probably could not. I have a fishing pole or something else. I just think there's some consequences that people need to understand. That I get asked this question occasionally. I get stopped at Kroger or somewhere, and someone wants to ask a question about their right to do something, but what they're really trying to say is they want to be able to say, I asked the chief and the chief said it, and so therefore I'm good. So I got to kind of stay away from that and be careful. So you need to check with your local prosecutor. So, yeah.
I have another question. So you talked about in Ohio, stand your ground originally was your car in your home when it was signed into law in 2008. And now it has been expanded, 2 different governors. And so as we think about the future, if there's a new governor in place, new people in the legislation, is there an opportunity to crawl back on that law once it's been, the law has been put in place?
Pandora's box. Legally, yes. Practically, no. No. What we talked about in the presentation is that at first it was probably Florida and Oregon. And then it was Florida, Oregon, and Texas. We know Texas was probably Florida, Texas, and then Oregon. And now in 2021, 38 states. Ohio was the 36, which means in the 3 months that we passed it, 2 more states have passed. Kind of like legalized marijuana. We got 37 states now that have some form of legalization. Are they going to go back in that? Practically, no. Legally, sure, they could. But I don't see, and let's be politically honest. This is a state that now for the past 2 election cycles has supported the former president, Donald Trump. And each of the statewide elected officers of our state has more of a conservative bent on them than the folks who they were running against. How will that change in the next 5, 10, 15 years? I don't know that it will. So no, from a practical standpoint, that I don't see that happening.
All right. Any other questions?
Yes. Sorry. Okay, so I have a question from the audience. So what about the instances where people, specifically white women, are pretending to be in danger when they aren't? What if it escalates? How will threat be determined?
Pretending to be in danger. How well is their acting on that?
Well, the recent video of the white woman having a breakdown in Victoria's Secret that's been floating around the internet. This white woman attacked this Victoria's Secret staff member. And she's recording this white woman like almost hitting her. And then the white woman realizes that she's being recorded and she starts like freaking out, like falling on the floor, pointing, like literally shaking, and just carrying on like she is in some sort of danger. So if you were walked in on a scene like that, how would you determine threat?
I'm gonna need to know a little bit more probably from what was her mindset to cause her to believe that she was being threatened. And I have to pull that out from the alleged victim. You need to articulate your actions to me. I can't assume anything. You want to tell me what your fear is and how did you arrive at that. And if they can't articulate that, then I think they're just using it as a crutch, and we'll see it for what it is.
Does community policing, knowing the culture of the community, have an impact on perceived threats in the community?
Okay, you meant to repeat that.
So we know that the community would, their preference is that officers live in the community that they police, and that they know the culture of that community. Does that help or harm in educating officers on what is a perceived threat? So what is a real threat? So I think that that can be like a segue from Kendra's question.
I think it's going to come down to the individual, what their mindset is and their perception of that is. It's got to be gauged on a case by case. What you may perceive as a threat, me living here in this community, I may not see that as a threat. I may be walked past that 5 or 6 times. You know, somebody shooting dice on the corner and drinking a 40. Is that a threat to me? Probably not, but it could be perceived to be a threat or something that's unwanted in the community by someone else.
There was a woman in Central Park who perceived that the black man who asked her to put her dog on a leash was a threat. There was a young woman in New York who perceived that a young black man had stolen her cell phone, left it in the back of her car, back of an Uber. Again, there was a perception of a threat when a young lady knocked on the door in the suburbs when her car had broken down. There was a perception of a threat. There was actually an undercover officer, and this is a different story, not actually posted about earlier, but an undercover officer was shot and killed by his fellow officers because they saw him out of uniform and didn't realize that he was an undercover officer, and they shot him and killed him. This is New Jersey about 10, 11 years ago. So the perception of a threat is subjective. My father used to talk about the fact that my grandmother was deathly afraid of snakes. She just scared of snakes. I ain't afraid of snakes. But if a bumblebee comes too close to me, now I'm not saying for real, I'm just saying as an example. but if some type of, stinging killer wasp come close to me, that's threatening to me. That my personal subjective fear is as real as my grandmother's about that snake. And so it's individual. What the problem is when those threats are universally unreasonable. And so is it universally or objectively reasonable for someone to perceive me, Fanon Rucker, walking down the street to be a threat? Why? What about what I'm doing presents a threat? Do I have a gun on my hip? No. Do I have a briefcase that could have a bomb in it? Not particularly. Is it my haircut? Is it my glasses? Is it the fact that I'm wearing a mask, even though there's a mask mandate and everybody around the country is supposed to? But how objectively reasonable is that subjective fear that a person has? And, we see a whole lot of cases out here where people's subjective belief that they are somehow in danger is unreasonable to the massive amounts of us. And that's why you get lawsuits filed by folks like Rucker, the Chicago firm, because folks make accusations in situations where they really don't have a reason to.
I have a final question for me.
Can I
sure.
expand on that? With regards to looking suspicious, I have a real issue with that if there's no articulation. If that's in a report that I see that my officer has generated, I need to have articulation with that. We're a predominantly Black, African-American community. Our police force is predominantly white. If that's in our reports, I need to understand whether it's the white officer or Black officer who put that in the report. What about that was suspicious? What's that umbrella look like? What's underneath all that? Is that just a word that's been thrown out to help you try to achieve something that you're trying to do? Or was there really something there? You just can't say, in other words, what I'm saying, it comes across my desk, I'm looking at it, where's the articulation? If the articulation is not there, then may have done something you shouldn't have done. So I want to make sure they understand that, and they know that's in the report. In fact, it's really never used because they know now that they don't want to use that word, I need articulation. So it's been embedded in them to do it a different way.
So a follow-up to that, do you believe that other police chiefs in Hamilton County operates the same way that you do when it comes to perceived threat?
I don't know if I can speak to that.
Okay.
I just let you know what we're trying to do here to make my little piece of the pie shine as well as it can. So I think that my colleagues are doing the best they can for what I know. I don't know of anything that I can point out. So I think that overall, out of the 42 law enforcement agencies, we're all out here trying to do the best we can.
So we're actually going to take the time to wrap up. And before I kick it to Vice Mayor Trabue, I did want to say that, one, it sounds like that this law should have never been expanded in the first place. There is confusion even amongst law enforcement and seasoned attorneys, former judges, on how it can or should be applied, which means that everyday experts or residents would have a difficult time deciding what they have the right to do where, especially if you are Black. If I've learned anything today is that we really need to hold our elected officials accountable to our interests. And before they implement any policy, they need to evaluate the impact that it's going to have on us, because we're having this conversation several months after this has been signed by Governor DeWine. So with that, I will kick it over to Vice Mayor to close us out.
Thank you, Raquel. So as we close, just want to reiterate a couple of data points that were shared earlier today as it relates to stand your ground laws. And at this point, I'm speaking particularly to people of color and more specifically to Black people as it relates to this law. We have seen stand your grounds are associated with an increase in homicide rates since they have been in place. In Florida in particular, they've seen a 75% increase in justifiable homicide, 22% in unlawful homicide. Across the United States, we've seen more than 150 additional gun deaths each month. We have seen stand your ground being associated with an 8% net increase in the number of reported murders and non-negligent manslaughters. Individuals are more likely to avoid charges if the victim is Black or Latino, but not if the victim is white. We've seen individuals that are 2 times more likely to be convicted in a case that involves a white victim compared to those involving a Black or Latino victim. And last but not least, homicides in which white shooters are killing Black victims are deemed justifiable 5 times more frequently than when the situation is reversed. So I say all of that to say to our people of color and our Black people in particular, do not be deceived. This law was not enacted to protect us. I would advise people to do their own research, to think before they act, before you go buy that gun thinking that this law is going to protect you. Really think about that. Look at the data. Reach out to the Center for Social Justice for more information before you make that decision, because I would hate to see someone who believes that they're standing their ground and defending themselves have to go to jail because another law was put into place that does not protect us. So on behalf of the Village of Woodlawn, I would like to say thank you again to the Center for Social Justice, to Fanon Rucker, especially to our police chief. Thank you for your leadership. As you mentioned before, and he'll probably chuckle a little bit when I say this, myself and our mayor and council members, we have lots of conversations about our police force and talking about working to increase diversity because we know our community is predominantly Black, but most of our officers are white. And to our officers, if you're watching this, we appreciate you. That's not to say that we don't. But we are very blessed to have a police chief that understands that asks those hard questions that is working to hold his officers accountable in situations like this. So again, thank you all very much. We want to encourage you. We will be sending out a survey for those of you who watch this. We want to know if you have additional questions, and we also want to know if there are additional topics that you would like for us to cover, because we would love to host something like this again in the future. Good night, everyone.